Ano ba ang nangyayari sa isang criminal case? What should you expect to happen kung ikaw ay may kasong kriminal? Let's find out after this intro. To know the step-by-step process of a criminal case involves the study of criminal procedure. One semester din po ito sa law school. Ganon din sa criminology, it forms part of the curriculum. But this time, I would like to give you a glimpse kung ano ba yung mga stages na pinagdadaanan ng isang criminal case. Ito ay base sa ating rules of criminal procedure. Ito yung aking version ng basic criminal procedure o criminal procedure simplified. And to make sure na updated kayo sa mga videos na ina-upload ko, please subscribe to this channel. And make sure also that you were able to hit that notification bell. If you are watching this video on Facebook, paki-follow na rin ng page na ito. And sa ganun, magiging updated kayo sa mga pangyayari. Actually, I have made 3 videos already that dealt with criminal procedure. First, the Miranda Doctrine in relation to arrest. Second, sub pena in relation to the preliminary investigation conducted by the prosecutor. And third, warrantless arrest. You can watch them later, but for now, tapusin niyo muna ang video na ito. So, bakit nga ba may criminal procedure? Ano ba ang criminal procedure?
What is criminal procedure? It is the method prescribed by law for the apprehension and prosecution of persons accused of any criminal offense and for their punishment in case of conviction. In other words, ito ang proseso at pamamaraang itinakda at isinasaad ng batas sa pagdakip at pag-usig sa mga taong inaakusahang gumawa ng krimen at sa pagpapatupad ng parusa kung sakaling ito ay napatunayan. Criminal procedure is concerned with the procedural steps through which a criminal case passes, commencing with the initial investigation of a crime and concluding with the unconditional release of the offender. It simply means that ang criminal procedure ay naglalatag ng mga hakbang o step-by-step process na dinadaanan ng mga kasong kriminal magmula sa pag-iimbestiga ng isang krimen, sa pagsampa ng kaso, pag-issue ng arrest warrant at iba pang stages ng kaso hanggang sa paglaya ng isang offender.
Now, tingnan natin kung paano natin ina-apply ang criminal procedure.
It is safe to say that we have criminal procedure dahil sa mga taong gumagawa ng krimen. Everything starts from the commission of a crime. Meaning to say, magsisimulang gugulong ang batas kung may gagawa ng krimen. Paano kung pinagbintangan lang o di kaya gawa-gawa lang yung paratang? In that case, mas lalo nating kailangang may criminal procedure. Dahil dito, maisa sa katuparan ang constitutional guarantee of every person's right to due process of law. Dito malalaman kung may katotohanan ba ang paratang o akusasyon. Dalawa ang pwedeng mangyari kapag ang isang tao ay gumawa ng krimen. Una, maaari siyang maaresto kaagad when he committed a crime or is actually committing a crime o nagtatangka siyang gumawa ng krimen. Ito yung in flagrante delicto arrest. Maaari din siyang maaresto during a hot pursuit, that is, right after the commission of a crime. Ito yung warrantless arrest na pinag-usapan natin sa video na ito. I will put the link here so you can watch it later. Makikita nyo ang rules about arrest sa Rule 113 of the Rules of Criminal Procedure. In cases where a person is arrested and detained under this situation, sinasabi ng Rule 112 Section 7 na dapat siyang i-inquest ng prosecutor. This is to determine kung tama ba ang ginawang pag-aresto at kung may sapat ba na ebidensya upang kasuhan ang inaresto. Pag-uusapan natin ang inquest proceeding na yan in a separate video. Second scenario ay kung hindi naaresto yung suspect sa krimen. Ibig sabihin, at large yung suspect. In this case, magsasampa ngayon ng complaint sa Office of the Prosecutor upang magkaroon ng preliminary investigation. Upang malaman natin kung kailangan pang dumaan sa preliminary investigation yung isang kaso o pwede na itong i-direct filing na lang sa korte, we need to refer to Rule 112 of the Rules of Criminal Procedure. Rule 112 also lays down kung ano-ano yung mga steps sa paggandak ng preliminary investigation. Ang purpose ng preliminary investigation is to determine kung may probable cause ba upang sampahan ng kasong kriminal ang respondent. Ito yung pinag-usapan natin sa video na ito. I will also post the link here, but watch it later na lang po. Tapusin niyo muna tong video na to, okay?
Pagkatapos ng preliminary investigation, unang inquest, ano ba ang susunod na mangyari?
Dalawang bagay din po ang pwedeng kahihinatnan ng isang kaso sa preliminary investigation at inquest. Either makikitaan ng basihan upang i-file ng prosecutor ang kaso sa korte o ibasura ito dahil walang probable cause o walang sapat na ebidensya. In case of dismissal, maaari pang magsagawa ng karagdagang investigasyon ang ahensyang nag-iimbestiga sa kaso. Kung may sapat na basihan, magpa-file ang prosecutor ng kasong kriminal sa korte. Ito ay sa pamamagitan ng pag-file ng information. Nasa Rule 110 po ito ng Rules of Criminal Procedure. Kung saang korte dapat i-file yung kaso, pag-uusapan po natin yan sa mga susunod na videos. Meron po tayong Sandigang Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in Cities, at Municipal Circuit Trial Court. At iba-iba po ang jurisdictions ng mga ito. Kapag satisfied ang korte na may probable cause, mag-i-issue po ito ng warrant of arrest kung at large pa ang akusado at commitment order naman kung detained na ang akusado. Nakasaad po ito sa Section 6, Rule 112 of the Rules of Criminal Procedure. Take note, kung respondent ang tawag sa kanya during the preliminary investigation, accused na ang tawag sa kanya ngayong naisampa na ang kaso sa korte. Magkaiba po ang arrest warrant at search warrant. Ang search warrant po is governed by Rule 126 of the Rules of Criminal Procedure. Maaari pong ma-issue ang search warrant kahit wala pang kasong naisampa sa korte at maaari din itong ma-issue during the pendency of a criminal case, yung may nakasampa na. Pag-uusapan din po natin yan in our future video, including yung mga provisional remedies under Rule 127 wherein maaaring i-attach o i-freeze yung mga assets ng akusado to answer for the civil liability later on.
Kung nakadetain na yung respondent o yung akusado, under what circumstances na pwede na siyang magpiyansa?
Isa sa mga remedies ng isang respondent o akusado na nakadetain ay ang mag-post ng bail o piyansa. This is found under Rule 114 of the Rules of Criminal Procedure. Kung ang respondent ay nakadetain, maaari siyang mag-apply for bail kahit hindi pa na-file yung kaso sa korte. Ito yung instance na naaresto yung suspect at nang siya ay in-inquest, nag-invoke siya ng right to a preliminary investigation, waiving the provision of Article 125 of the Revised Penal Code. Don't worry, I will explain that in a separate video on inquest. Ang bail ay isang security para sa pansamantalang paglaya ng isang akusado habang nililitis ang kanyang kaso. It could be a matter of right or a matter of discretion. Pag-uusapan din po natin yan in a separate video. At this point, mainam na ring pag-usapan ang rights of the accused under Rule 115 of the Rules of Criminal Procedure. Hango ito sa Bill of Rights, Article 3 of the 1987 Constitution na nagsasaad ng mga karapatan ng isang akusado. Kabilang dito yung right to be presumed innocent until the contrary is proved beyond reasonable doubt, the right to be informed of the nature and cause of the accusation against him, the right to be present and defend in person and by counsel at every stage of the proceeding, the right against self-incrimination, the right to confront and cross-examine the witnesses against him, the right to have speedy, impartial, and public trial, and the right to appeal.
Now that the case has already been filed in court, what should you expect sa paggulong ng kaso sa korte?
Bago pa man gumalaw ang isang criminal case sa korte, maaari na itong madismiss kung may ground for its quashal. Under Rule 117 of the Rules of Criminal Procedure, maaaring mag-file ang akusado ng motion to quash. Ilan sa mga halimbawa ng grounds ng motion to quash ay kung walang jurisdiction ang korte, kung may double jeopardy o nag-prescribe na yung crime. Kailangang ma-file ang motion to quash bago ang arraignment. Ano naman ang arraignment? Ito yung stage kung saan binabasa ang information o sakdal sa akusado at tinatanong siya if he or she pleads guilty or not guilty. Dahil ito sa constitutional rights of the accused to be informed of the nature and cause of the accusation against him or her. Dito rin kadalasan ginagawa ang plea bargaining kung saan maaaring umamin ang akusado o mag-plead guilty siya to a lesser offense which is necessarily included in the offense charged. May mga requirements at conditions po ito sa ilalim ng Rule 116 of the Rules of Criminal Procedure. Pagkatapos ng arraignment ay ang preliminary conference at pre-trial. Napag-uusapan din dito yung plea bargaining, pag-stipulate ng facts kung saan nagkakaroon ng admission kung totoo upang mapadali yung kaso, pagmarka ng mga ebidensya at iba pa. Maaari ding i-refer ng korte ang kaso sa Philippine Mediation Center for Mediation. Then, the trial. Dito na ipinapresenta ang mga testigo o testimonial evidence at iba pang mga ebidensya. Under normal circumstances, nauuna ang prosecution sa pagpresenta ng ebidensya, then ang defense. Kapag insufficient o hindi sapat yung ebidensya ng prosecution, maaaring ipadismiss ng defense ang kaso by filing a demurrer to evidence with or without leave of court. But in the case of a reverse trial order, nauuna ang depensa sa pagpresenta ng ebidensya. Halimbawa nito ay kung ang theory ng akusado ay self-defense, in which case may admission ng act pero sinasabi niyang nagawa niya lang yun dahil sa pagdepensa niya sa kanyang sarili. The conduct of trial is governed by Rule 119 of the Rules of Criminal Procedure and the revised guidelines for continuous trial of criminal cases. When both parties have completed the presentation of their respective evidence and the court has already ruled on the formal offer of evidence, magdidesisyon na ngayon ang korte. Nakasaad ang mga requirements ng valid judgment sa Rule 120 of the Rules of Criminal Procedure. After the judgment is surrendered, maaaring mag-file ng motion for new trial or for reconsideration ang akusado. Limited lang ang grounds for a new trial at reconsideration. Hindi maaaring mag-file ng motion for new trial or for reconsideration ang prosecution dahil mag-constitute ito ng double jeopardy. Under Section 21, Article 3 of the 1987 Constitution, no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Ganun din po sa appeal. Any party may appeal from a judgment or final order unless the accused will be placed in double jeopardy. Ang desisyon ng Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit Trial Court, at Municipal Trial Court in cities ay maaaring iapila sa Regional Trial Court. Ang desisyon naman ng Regional Trial Court ay maaaring iakyat on appeal sa Court of Appeals. At ang desisyon ng Court of Appeals ay maaaring iapila sa Supreme Court. Ganon din po sa Sandigan Bayan, maaaring iapila ang mga desisyon nito sa Supreme Court.
Ayun, natapos din. Thank you for watching this video. I hope that you have learned something. Again, don't forget to subscribe to this channel and to click that notification bell dahil marami pa po tayong pag-uusapan at lilinawin tungkol sa ating batas. Always remember, ignorance of the law excuses no one from compliance therewith. Until next time, stay safe po tayong lahat.